This video under Section 107 of the Copyright Act of 1976. Allowances is made for fair use for purposes such as criticism, comment, news reporting, education, and research. Fair use is permitted by copyright statute that might otherwise be infringing. Smash that like button. Let's go. Back with another live. Hey, y'all. So we are going to get into the cross of Cassie. Of course, it is a new day. So, of course, they have things to iron out when they get into the courtroom and everything like that. Excuse me for the tardiness. It was really not mine. I didn't mean to be tardy. I didn't mean to schedule this that late. But I just kind of got like the transcripts and put it all together. But anywho, we're gonna have a great day. I more than likely will be back on tonight to continue the reading of the transcript. Give me 1 second here. 1 second. Let me just do that. Hold on 1 moment. I just need to send something out. All right. So yeah, all right. So yeah, and we are back. Let me just fix this really quick. All right. All right. So we're back. All right. So I'm back. So we're going to get into the transcript reading of the transcript reading of Cassie. Finally, we're going to see something. Finally, we're going to be. Oh yeah, I like this one better. Okay. So finally, we're going to be getting to Cassie's cross. I know on direct it was so long. So long. It was very it was a lot. So yeah, getting into the trial, just a little bit about what was going on yesterday. Yesterday was yesterday was a pretty hectic day in the courtroom, right? There are, remember I told you guys that you have to be responsible with your platform. You have to be responsible with your platform when you're reporting on these issues, especially when it is a high profile case. You have to be very, very careful reporting on these issues. You have to know what's going on with the court. You need to be on top of that when doing reporting on these high profile cases. So I can read from these transcripts. They're public. They actually come from the court. So I can read from these official court transcripts because they're coming directly from the court. But what I also have to do is abide by the rules that the judge puts forth inside of the court. Take for example, let me let you know what's going on right about now. I had only saw one content creator that had doxed Mia, showed her picture, and said her name. Right then and there, I said that this was going to be an issue. This was going to be a problem because I knew that it was going to be an issue. It was going to be a problem. You cannot, this is a federal case. This is like you're interfering with a federal case. She testified under a pseudonym for a reason. And so she was not only doxxed by the one person that I know of, she was doxxed by 3 content creators. And I don't even think that they have told the court yet about the content creator that I'm speaking of. I don't think so, because the title of their video does not say anything about Mia, the victim / assistant that testified in this case. However, and one of the how I know that they're not the content creator that I'm talking about, they're not talking about her. Ooh, I said I gave you a God dog it. So how I know they're not talking about the content creator that I'm talking about is because one of the content creators is on Twitter. So there are, news stations reporting about this, and they have it kind of correct, but it's incorrect. There are 3 content creators that are banned from the courtroom. Possibly will be there will be looking to bring charges on these 3 content creators. They're banned from the courtroom. And the person who doxed her on Twitter, I guess the government will be in touch with them. They want it down. They want it down. When I tell you they are not playing, they want it down. I tried to tell people, and they had the pictures of the content creators. They have their channels, everything. This is not a joke. You have to be responsible with your platform. It's not a joke, people. I told you it's not a joke. 3 content creators banned from ever coming back into the courtroom and covering this case. So I do have to send out a big trigger warning before we start the reading of the transcript. This video is not for kids. And let me see something. I wanted to check something myself. Yeah, that's what I wanted to do because I feel like somebody is playing in my face. Let me see something really, really quick. Works for me. So, all right, works for me. So I'll leave it back up there. Yeah. So, so that's, excuse me, that's that on that. that is that on that. People, be careful what you're doing with your platforms. They are watching. People who are reporting on the P. Diddy trial. I'm just saying, I'm a small YouTuber. If you don't have to listen to me, you don't have to listen to moi. But I'm telling you that they are watching, they are looking, and please, and thank you. If you happen to slide up through here, this is early enough in the video. If you're a content creator and you happen to slide up and through here, just know that they are watching. You will be banned from the courtroom. Hold on 1 second here. Let me see something here. Okay. Okay. So moving right along, we're going to get into this reading. This is we're on day 4. Actually, this is part 6. Trying to get through this Cassie. Cassie started on Cross. We're trying to get through it. I know that they have a whole bunch of stuff that they're going to be hashing through in the beginning of this. Like I said, if you're here watching, like the video if you're over here on YouTube. And if you're over on X, please consider coming over to YouTube to like the video. It's a free way to support the show. Actually, you could just type in Survivor Speaks. One of my mods, let me see if I can do it. Let me see if I can see it really quick. All right. Let me see if I can drop the link over there so you guys can come over here. Just hit the like button, if you will. Free way to support the YouTube channel. I would appreciate it greatly. And you can go back and watch on X if you like. Let's see. Here we are. There we are. Oh no. Let's see. Oh, here I go. All right, so and subscribe. Okay, so I have put a link in the chat over here on X. And so let's get back into it here. So As I stated, I know there's one content creator on Twitter. There's 2 content creators on YouTube so far. The courts have banned them. If they ever come to the courtroom, they cannot come inside the courtroom. I already explained you have to be responsible with your platform. And like I said, the witness Mia testified under a pseudonym for a reason. And so there have been people who have doxed her, who have put up her picture. They have put up her real names. And I'm telling you that the courts are watching when people are reporting on the Diddy trial. You have to be responsible with your platforms. So they are not allowed back in the courtroom, and they may consider possible possible charges, against these content creators. I know one content creator. I don't think that they've seen her yet, but she should consider editing her video and taking the last part out of her video, because so far I don't think it's her, because she doesn't have in her video. She did not have in the beginning Mia's information, but her information is at the end of her video. All I'm saying is, I think you need to edit that video, take out the last part of it, because even the video that you shared, that it is your intellectual property, it is you, but at the end you didn't have to add that. And so, yeah, you cannot, you also have to, when you're reporting, you have to also stay on top of what's going on in the courtroom. And if the judge is saying, and the parties have agreed that, yes, this is how she's going to testify, when you're reporting on this content, then you have to abide by the courts. So now, yeah, they have banned 3 people. You can no longer come to this trial, and maybe facing possible charges. Listen, this is a government case. That's considered interfering with a federal case. This is the feds. This is the government. You cannot play with this stuff. The only reason why I can read these official transcripts is because it is released to the public already. This is what they are. It's released to the public. You have to pay for these transcripts. This is directly from the courts. So anything that should be redacted in these transcripts, if anything, it's already redacted once, we purchase the transcripts. So I'm just saying to everybody, be responsible and be very, very careful when you are reporting on these, especially these high profile cases. You have to know. You have to know what's going on when you're reporting. All right, so let's get right back. We're getting right into it. We're going to be starting now. We're on day 4, finally on day 4, where Cassie Ventura is going to be crossed. But of course, this is the morning, the very top of the morning on day 4. And of course, they have things to hash out. Hopefully your girl just doesn't lose. Hopefully your girl just doesn't lose my voice during this. We may be stopping at an awkward place. I have an ongoing family emergency, and I take care of my mom, but she's getting back to herself. So the way I am able to go live in the morning is because she's out, and then she comes back home in the afternoon, and I need to be there when she gets home to make sure that she's okay. So that is why we may be stopping at an awkward place today, depending on the time. So let's get right into it. All right. So now they're back in the court, and the trial is resumed. Jury not present. So the court says who's going to be addressing the 412 issue from the defense's side. It's going to be me, Judge. The court, Mr. Agnifilo, can you put Rule 412 to the side for a minute? Of course. How are you getting these exhibits into evidence? Just walk me through that. So for text messages, we're going to ask the witness, just like the government did. You see this text message? Is this a fair and accurate text exchange between you and the defendant? The court. Well, there are no objections raised. So let's assume there has been an objection raised. How are you going to get these in? Are these prior inconsistent statements? What are you doing? The judge wants to know. What are you doing? I hear you, but what are you doing? Because the defense has been playing pretty dirty so far, right? So the judge wants to ensure that he is protecting the record, and he is protecting the record and for the appellate purposes, right? So he wants to know, how are you going to do this? Right? How are you going to go about doing what you're going to do? Let me know. So, most are not offered for the truth of any assertion. So in the first instance, I believe most of the proffered text messages are not hearsay to begin with, because there's no assertion being offered for its truth. I think Your Honor made reference, I think it was a few days ago, that part of what may be relevant, we're saying that it's very relevant in this case, is the nature of the relationship. This is a relationship that took place largely over text message. They communicated about everything. I understand. I had that question. You're saying they're not being brought in for the truth of the matter asserted. They're being brought in either for context or, I suppose, the defendant's state of mind. That's right. Or Ms. Ventura's state of mind, because she would need to, for the trafficking count, there would need to be coercion. But I think it's probably most relevant for Mr. Combs' state of mind. I don't even know that we necessarily get that far, because if they are not being offered for the truth, if they are just being offered to show context and how the relationship progressed, I think it ends there, because there's no hearsay statement. There's no statement that's defined as hearsay. I understand. All right. The defense argues that the messages at issue are not being offered to show either that a victim engaged in other sexual behavior or to prove a victim's sexual predisposition. However, the defense cited no case indicating that where evidence of a victim's sexual behavior or a sexual predisposition, which this is brought in for a different purpose here, context, or the accused's state of mind, that Rule 412 would not apply. In fact, this would impose by judicial fiat an exception that is not encompassed by 412B. The Fourth Circuit has just gestured an exception, the Doe case, but it appears to be the only court that has adopted any exception along those lines. And the exception was itself questioned by the Fourth Circuit in the Saunders case, which is cited by the government. The advisory committee notes, moreover, that the amendment to the rule to address sexual predisposition was intended to exclude evidence that does not directly refer to sexual activities or thoughts, but that the proponent believes may have a sexual connotation for the fact finder. These messages fit the bill. Rule 412 applies. Your Honor, can I be heard? Let me finish. I'll do the same thing which we've always done, which is you can react to what I'm saying. Sit down. He said, slow down. Sit down. Sit down, Mr. Agnafilo. Sit down. I'm not done yet. You can jump in when I'm done. Let me finish. Which they said Mr. Agnafilo made a fool of himself in the courtroom yesterday trying to be Brian Steele. It didn't fare well for him. It didn't work out. So sit on down and let the big boys do the work, sir. Learn here. Learn. It's just so much. Yesterday was such There was so much going on in the courtroom yesterday. I was told they had to kick somebody out of the room, out of the courtroom, also, who had made an outburst because the court day. It was a bad day for Diddy yesterday. They really, really, really introduced Rico into this case. Anybody today, and I still saw some people reporting that that's not Rico. What do you mean it's not Rico? It's Rico. He paid a security guard who testified yesterday $100,000 to give him the thumb drive that contained the video from the Intercontinental Hotel the day that we all saw that CNN dropped, right? He paid him $100,000. First Christina Coram. Oh my gosh, this lady is just co-defendant. I don't think they'll offer her immunity. I don't know. Let's see. Christina Coram went to the hotel to try to get the footage. She wanted to see it. They didn't show it to her. The security guard, Mr. Garcia, I don't have enough power to even access the room to locate the video to show it to you. I can't do that. I can't do it. So they call this guy on his cell phone. He has no knowledge about how they got his number. Christina Coram calls him and puts P. Diddy, Puff Daddy, Brother Love, Pop, Poppy, Love on top, Tucci on bottom, on the phone. And he starts pleading his case, how he needs to get rid of the video. He needs to get rid of that video. It cannot get out there. The video footage cannot get out there. It's going to ruin me. You seem like a good guy. I'm sure you could get it done, Eddie. So Eddie's like, I'm not sure. I'll make it worth your while. Let me see what I can do. He goes and he talks to the boss. And the boss said, look, I'll do it for $50K. So he calls the number that they call him from. Christina Coram answers the phone. KK, if you will. Hands the phone to Diddy. Love on top, Tucci on the bottom. He's like, hello? My boss said he'll do it for $50K. That was right up P. Diddy's alley. He's like, oh, Eddie, my angel. Eddie, you're my angel. I knew that you can do it. I knew that you could do it. Like the little engine that good. Eddie, can you get it? And we'll send you the address of where to bring it? I don't know how I'll be able to do that. I'm on the clock. I'm working. You can do it, Eddie. You're my angel. I believe in you, Eddie. You can get it done, Eddie. Eddie asks his boss, and his boss says, well, have the other guys cover you. Go on to the address. Bring the video. He brings the video. He's met by security at this address. He's taken up. And the security guard says something to him like, yeah, Mr. Combs said that you're an angel, you're a good guy. That's that could be looked at as fear. You're putting fear into this person. You have this big security guard. That means that you guys have been having conversations about me. Right? Gets to the floor. Elevator opens. Diddy standing there. Eddie, my angel. I knew you could do it, Eddie. You're a good guy. Where is the thumb drive? This fool brings out a money counting machine and a brown paper bag full of money. He puts the money in a money counter, counts out $100K. Now they only ask for 50. He gives them an extra 50. Diddy. Has him sign an NDA. Tells him that he needs 2 other people to sign this NDA. Officer Flores, who was a security guard at the time, and the assistant director wasn't going for none of that. He could not be bought. Not me. So the director above him signed, and they found another security officer to sign and Eddie's signature. They could not talk about the tape, whatever, you know how the NDA goes. And the NDA was written on the Bad Boy Enterprise letterhead. So now, this is the Enterprise. He's the Enterprise. This is bribery. How else do you look at it? You got Christina Coram, KK. She is like his number one right-hand gal, if you will. She's with the itch. She is, you're come through Christina to get through to Diddy. So he said, "Are you sure this is the only tape?" He called the hotel. He wants to know if this is the only tape that there is of that incident. Yes, this is the only tape. Eddie, I knew you could do it. Eddie, my boy, you could do it. I knew it. So he said, "Eddie, you want to count out the money yourself to make sure it's all there?" He's like, "No, I trust the money counter." Eddie was what? I think 24, they said at the time. 22 or 24. Very young, very impressionable. This is the instructions that Diddy gave him. Do not start spending money foolishly, all willy-nilly. Do not make any large purchases. We don't want to bring any attention to the fact that you now have money. So what do? He buys him a used car. But how would anybody this is cash you gave them. You paid them in cash. What, unless they were telling these security officers for whatever reason, why would anybody know what he's spending, how he's spending? So he got 30K of the cut. The big boss got 50K, and the other 20 went to the other officer, the security officer that signed his signature. You can't make this up. Diddy do it, Diddy. Finished. CFO came and testified yesterday. Y'all remember the $20,000 that Diddy told Cassie's mother she needed to pay him because, Cassie had left him. She was dating Kid Cudi. You need to pay me my money back, the money I invested in her, even though the record label, because there's a label over Bad Boy that was pumping the money. A parent company over Bad Boy. So you were paid. You didn't do what you said you was going to. You used the money that they gave you for freak offs to make her music for freak offs and other things like that. Child. So the CFO was on the stand. He brings the documents in. There's that $20K, and it shows that 4 days later he sent it back. That's still extortion. The fact that you could have stopped it before it was even sent, and then you sent it into the business account. Extortion. There it is. I keep telling people, if you rob me and on your way leaving, you have a change of heart. Let me go back. Survivor Speaks didn't deserve that. Let me take this back to her. I really didn't want to rob her. I shouldn't have did it. Somehow your conscience, the man on your shoulder says, you go back. Give Survivor Speaks her stuff back. You still robbed me. I don't know how else to explain it. You still robbed me. That's all I could say. You robbed me. You robbed me. You robbed me. Thank you for my stuff back, but you still robbed me. The cops is on the way. Do you think the cops is going to say, oh, okay, you robbed her, but you brought it back, so we're going to let you go? No, they're going to lock you up, and that's going to be part of the report. At 10 blank, blank, blank a.m. Eastern Standard Time, or Central Standard Time, Pacific Standard Time, we received a call from Survivor Speaks advising that she had been robbed. Upon entering where Survivor Speaks was, the robber was there when we arrived and stated, I gave the stuff back. I did take it, but she has it. Sir, I'm gonna need to read you your Miranda rights, okay? You have the right to remain silent. Anything that you say can be held against you in a court of law. You have a right to an attorney. All that, the Miranda warnings, we all should know them. Anything you say could be used against you in a court of law. So yeah, sir, we're gonna have to take you down here and book you. And you're going to have to see the judge, and the judge can figure out whether or not you'll have a bond or not. It doesn't make a difference that you decided to have a good heart and bring this stuff back, and your conscience was eating you up, and you brought it back. So you robbed her. So you're going to be charged with such robbery. And you better hope they don't find some other stuff for child. Anyway, I don't know. I guess, in Diddy's world, we're all stupid. The public is stupid. The people that support him are stupid. The courts are stupid. That's what I think he believes. And his defense team, I don't know what y'all doing. I'm going to get on with the reading because I'm going to come back later and go live. I'll come back later and go live, definitely. And I'll talk about the second piece. That's about something that happened yesterday. I'm going to talk about it later. I'm going to get into these docs, though. Oh, my goodness. Oh, my goodness. Oh, my goodness. They thought they had Mia. Ooh. The United States government has taken the gloves completely off. They're not playing no more. They don't play anyway. When you're in the fit, but they're not playing anymore. They took the gloves off. Those 6 female prosecutors for the United States. Baby, they took off their skirt suits and they put on their pantsuits and their boxing gloves and they are ready to squabble up. Squabble up. Let's go. Legally, I mean. But they're ready to squabble up. They came with the fire. They came in court yesterday with the fire. And now, anything goes. Oh, Mia's testimony might stand anyway. They are going to resuscitate Mia's testimony. Brian Steele, oh my gosh, Brian Steele. Yeah, y'all know Brian Steele is one of my favorites. Let's get on to this because they trying it. They trying all types of stuff. But let's go. All right, so the evidence does not fall within any of the exceptions listed in 412B. The only exception that defense points to is B1C, which refers to evidence whose exclusion would violate the defendant's constitutional rights. Here, as the defense acknowledged yesterday and as the government acknowledges in their letter, witnesses can be cross-examined on relationships with other people, even questioning on whether those relationships were intimate in nature, and communications between Mr. Combs and witnesses, such as Ms. Ventura, concerning all of that are fair game, save for the very small category of messages at issue, which the government offers can be redacted and then omitted, which goes to show how much of a tempest in a teapot this issue really is. Even if there were potentially any constitutional dimension to this issue, and there is not, the procedures required in Rule 412C were all flouted. While the defense may claim there is good cause to excuse their failure to bring this issue to the court's attention sooner, the court disagrees. When the defense struck deal with the government, as memorialized in the March 28, 2025 letter, it was aware that there was an issue relating to Rule 412, and the language employed in the letter was conspicuously vague. The defense apparently did not advise the government that they would be introducing evidence about, for instance, Mr. Combs advising Ms. Ventura that he believed she was having sexual encounters with other people. I won't get into the language employed in the messages. So instead, saying that while it would introduce evidence of romantic relationships, it would not introduce evidence of any specific sexual acts between the alleged victims and these other people. So the evidence will be excluded in any event for failing to follow Rule 412C. The evidence will also be excluded on Rule 403 grounds. Too much. It's cumulative. 403. Cumulative. All right, grounds for the reasons stated above. The probative nature of the specific messages that are referenced is minimal, given that the witnesses can be cross-examined on their relationships with each other, including whether those relationships were intimate in nature, and communications relating to all of that are fair game, including any questions to any witness about Mr. Combs communicating that he was jealous or suspected that there was infidelity on the part of the witness being examined. On the other side of the ledger, there is a high degree of unfair prejudice and potential victimization of the people who are testifying, which is precisely the point of Rule 412 and why it was adopted in the first place. To prevent this kind of thing from happening, however, the exhibits unredacted can be used to refresh a witness's recollection, as Rule 412 solely applies to the omission of exhibits. The government further argues that the exhibits could be redacted because it is only the evidence of the actual behavior itself that Rule 412 covers, at least as the government acknowledges in its letter. Finally, there should be no issue with testimony again, because the issue of Mr. Combs' thoughts on infidelity, jealousy, etc., that goes to the defense's argument are fair game, and the government does not suggest otherwise. The truth is, this will not affect the defense's case in any way, shape, or form, other than to exclude plainly inadmissible messages that have questionable relevance to this case. Mr. Agnifilo. Thank you, Judge. We alluded to this yesterday, and I see that Your Honor's trying to strike a balance, but I want to put everything in a slightly different relief. I'm not trying to strike a balance. What's the case? What's your case or authority? Y'all better stop playing with Judge Aaron. He's not playing with y'all. Mr. Agnifilo, the crux is the agreement that Your Honor referenced, but there's a background to the agreement, as almost all agreements have. This is a subject that we discussed with the government extensively throughout March of this year, and I want to read the relevant paragraph of the agreement into the record, if I could, just to make sure. From the March 28th letter. Yes, Judge, because there's one particular paragraph, there's a few sentences that really is the whole heart of the argument here, and it reads as follows. In addition, we expect there will be evidence from both prosecution and defense as to relationships alleged victims had with people other than Mr. Combs. The defense may cross-examine witnesses and or introduce evidence as to interactions between Mr. Combs and the alleged victims regarding the existence of such relationships. However, the defense does not intend to introduce evidence of specific sexual acts between the alleged victims and these other people. We understand, based on our discussions with you, that the government agrees that such evidence does not implicate 412 as long as it does not involve specific sexual activities between the alleged victims and these third parties. Now, here's the import of that. Let me just pause you right there. Of course, in the letter that you submitted last, quote from the text messages, the specific parts of the messages. That's really what we're talking about. We're talking about specific words in specific messages. How would those not be specific sexual activities? The line that you just quoted from the letter, because again, the government isn't complaining about anything else, meaning they're not complaining as to this particular objection to anything other than about 8 words and specific messages. So let me ask you this before we get to the import of all of this. You're preparing your cross-examination and you're going through these exhibits. Did you go back to the government and confirm that these specific messages would be consistent with the agreement? And when did you do that? In terms of specific exhibits, we didn't do that until yesterday after. So how would you ever be in a position to establish good cause? Because if you had done it even 2 weeks ago, a week ago, then the government would have told you that they believed this fell under Rule 412 and did not fall within the parties' agreement, at which point you would have filed a motion with the court and you would have brought that to the court's attention in any one of the 15 or so hearings that we had in this court. And I would have addressed that then, right? I understand, but a few things that I think we have to all keep in mind. Every single piece of evidence that we're talking about, we got from the government. It's the text messages between Mr. Combs and Ms. Ventura that the government gave us. They had this material before we did. And this is important, I think, for the record. At the moment, I hear Your Honor. I know Your Honor has given this a lot of thought, as you always do. I'm just trying to sort of give Your Honor a different way of looking at the letter and the understandings. When we wrote this letter as the government conceding in the letter to our interpretation of the rule and how the rule applied to the facts of this case. 412 is contextual, and I think the court sees that in what the court said this morning. 412 will be different in every case, and the reason it will be different in every case is because of the requirement that 412 not violate the Constitution. That the requirement that 412 that means in this case, there's a defense that we have stated from get-go. And I think we even told the government in our meet and confers what our defense was going to be as relevant to these issues. which was this. There's going to be testimony on cross-examination, probably on direct, and there was. There's going to be exhibits, which is why we specifically we put in the letter examined witnesses and or introduced evidence. That is going to reflect anger, jealousy, betrayal over relationships, or perceived relationships. I don't like the perceived, because Diddy could just be some type of guy that everything is, she can walk by somebody can say hi, and she can say hello with her smile, and he would ask, "Are you effing them?" So yes, that would be excluded under 412. Like I said, there's a difference. The defense, child. Anyway, let me continue. Now the thought going in was that all of that was fair, regardless of how colorful, regardless the language that's used, and it's not human nature to express those types of strong emotions in flat language. They're going to be expressed colorfully. They're going to be expressed the way that they're expressed here. Our understanding going in was that if we got evidence from the government and discovery that they had, that they would have seen, and we've always been focused on the specific text messages. We're not talking about this tremendous universe of evidence. We're talking about the text messages between Mr. Combs and Miss Ventura. Keep throwing the jabs, Agnifilo. I'm catching them. First and foremost, that's always been sort of the heart of these discussions. That will be outside the purview of 412 that animated all our decisions in this case. That last sentence of that paragraph of the letter where the party said, if this is the case, it doesn't implicate 412. There's a little bit of a change in the agreement. The government is, I feel, backing away from the agreement that we struck them. The agreement was the entire issue. Oh, Mr. Agnifilo, keep on drawing them bows, because I'm catching them. Child, this man is a mess. I understand he's fighting for his client, but come on, his client probably told them, you got to get this in, even though as an attorney, he knows, you can't tell me that he knows that this is not cool. This is part of what they said they wouldn't do, and now you're trying to get it in. You done start, we got to wait and read through all this till we could get to the cross. God doggone it. In the context, now this is the judge of the court. In the context of making this agreement, there always has to be a meeting of the minds. And so did you tell the government we are going to put in messages that refer to actual conduct or discussions of a actualized nature? And just want to let you know we're going to be doing that. And are you okay with it? And the government responded and said, that's no problem. That's okay. Yes or no? Yes. The answer is yes. You are going to lie to the judge? Oh, my goodness. The defense. How are you going to sit here and lie to the judge when they have in black and white? What, Lord? The answer is yes. We had discussions. There's going to be text messages, and what they said, as long as it impacts on jealousy, on things like that within the purview of the case, that's totally different than what they don't have an issue with that. What they are having an issue is you guys discussing or asking questions about her having X with another person outside of Diddy and outside of these freak offs. How is it okay for them to defend him in a freak off with her having X with somebody else, but then they don't defend? Oh, well, it's nothing when it relates to that. But when it relates to Diddy sending her a text message, are you effing so-and-so? It is fair. Like, how, like, make it, yeah, people got to make it make sense. Because they have a child. When it's her having X in a freak off with Diddy, they want you to believe it's the swinger's life. But I guess and he had no proof that whether or not she was effing these people or not. He's just asking because he is diabolical. He is jealous, diabolical. He is a narcissist, and all of the other words that you can, colorful words that you can think of for, his character. Allegedly. All right, let's go. I can't. So, but Mr. Agnifilo, I want y'all to know he's standing here in line to the court. All right. So anyway, there's certain things we can't do. We can't go outside the communications between Combs and Ms. Ventura. If there's something else that an alleged victim in this case did that Mr. Combs doesn't know about and that doesn't animate the conduct, we can't go into that. And we've always known that. He didn't know whether she was after somebody or not. This is not related to Kid Cudi and all of them. This is not related to any of them. So, and you've had these discussions over email. I'd have to go back and check. We had the discussions. We had discussions specifically about evidence and not just testimony, but the evidence. The written communications were always the heart of this. Let me ask you this. Let's say I agree with you on everything. In what way is your defense in any way impaired given what I said, which is that the government is relaying about a few words. In fact, they are the ones that offer that you could redact messages. So let me just give you an example. I take it that there may be cross-examination of some witnesses in which they're going to be asked, isn't it true that repeatedly through your relationship, Mr. Combs raised questions about your relationships with other people? And you get whatever answer you get. You might be in a position to have to use certain messages to refresh the witness's recollection, etc. Government is saying you can do all of that. You can ask the questions. You can get the answers that you need. They're even saying if you need it, if you can satisfy all the requirements and get this admitted and put in front of the jury, that you can do that if you just redact these a little bit. There are ways to deal with this. The witness can see the unredacted emails and text messages, and it's just the jury that wouldn't receive the unredacted messages. But you could have the witness confirm that is underlying those redactions in a generalized way that would implicate the issues raised by 412. I'm not understanding why there's any issue really here. And this gets to not only Rule 412, but also Rule 403. And it also strongly indicates that there's not even an iota of any constitutional dimension to any of this, because your ability to cross-examine and confront these witnesses is not in any way impaired. I think that's the point the government is trying to make. Here on a purely practical level, here's what I propose. I'm going to look at my team as I say this and make sure I don't get dirty looks. Just go on ahead and say that you and your team are clashing. I don't believe we need to get into any of the challenge messages this morning. We do not need to get into any of the challenge messages this morning. Now that it's not 3:00 in the morning for the next few hours, while Miss Estavallo conducts the examination, Ms. Garagos and I will talk to the government, and we will try to bring about an agreed upon resolution to the outstanding issues. They already have a resolution. You don't like the resolution. That's your business. They have the resolution already. So just to be clear, we're not waiving. We hear the court. We're not waiving any of our objections. We're not waiving the constitutional. We're not waiving any of those things. But we are going to move forward and try to be practical and reach a resolution that makes trial run smoothly. We obviously, and the court as well, I'm not saying it's just us, we have to be mindful first and foremost of the constitutional implications of all of these issues. And we are acutely aware of that, and we must be. While I certainly understand Your Honor's view that with the solution Your Honor's proposing, the constitutional issues are not as paramount. I don't know what they're eliminating. I don't know what they're eliminated. I guess the devil's in the details. So we will do what we can to reach resolutions. He already gave you a resolution. You don't like the resolution. It's a very small point. It's easy. He already said that. You can show the witness. You just have to redact it when it goes back to the jury. And I just want to take one more step back. And this is one of those times it didn't happen. This letter was supposed to take this issue off the court's plate. That was the idea, that we wouldn't have all of these tricky 412 litigation issues before the trial. So he wanted them to take this off the court's plate so they can go ahead and run them up the way they want to run them up. No. Let the judge. The judge is the referee. Allow him to referee. Allow him to see past your bull crap and allow him to do his job. Okay, let's go. And I thought we had accomplished that. And I hear Your Honor. Looking back at it, a week ago, we would have tried to give them the exhibits. No, you wouldn't have. I know. I'm with you. We'll move forward. We won't address any of these things in the morning session, certainly. And in the meantime, when we have breaks or at lunch, we'll confer with the government and try to reach some resolutions. Your Honor, I need to correct the record on a couple of points for the record's sake, if that's all right with Your Honor. Of course, thank you. The meet and confers that led to the March 2025 letter were over the phone. There were 2 of them in March of 2025. On the first, the parties discussed the potential issues. We agreed to go our separate ways, do some research, come back. The second was on March 28th of 2025. You better not play with Miss Comey over here on the for the prosecution for the government. Listen, she got it all written. Listen, this is how you stand up. This is how you stand up in court and speak your ish. This is how you do it. You don't do it the way they're trying to do it over here. You're just trying to. Y'all thought this was going to be the trial by ambush, but y'all had to turn over the evidence that you were going to be presenting during this court. So I guess they thought that we're going to present it right before we cross. No, said the government. We got y'all. We not slow. We're not gonna have a mere moment. All right? We quick with it. We on our toes with it. You tried it. But anyway, let's go. We have internal notes, and our internal notes say that the government reads the rule to say, to the extent the parties want to omit evidence between victim and defendant, then 412 doesn't apply. If other actual contact with other people out of the contact within scope of charges that need to notice under 412. Defense counsel acknowledged that this makes sense, and defense counsel will make clear in letter to court what everyone's understanding is of the rule. And there were other discussions about potential notice. At no point in the notes or in any of our memories did defense counsel send us any text messages or alert us to any text messages, certainly not the text messages that are at issue here, as the kind of evidence that they might want to introduce to prove up these other relationships. So I forgive Mr. Agnifilo for probably thinking about a different conversation. We have talked about a lot of messages over the course of the last few weeks, but in the context of this particular meet and confer, there was no discussion of these text messages. And although Mr. Agnifilo is correct that all of these messages came from the government's own discovery, as I noted, the messages between Ms. Ventura and Mr. Combs total in the thousands of pages, and there are terabytes of data, and we were not on notice. We simply were not on notice that these text messages were going to be at issue. So I wanted to correct the record on that. You better go, Ms. Comey. I'm also told victim one's counsel still wants to be heard, if that's all right with Your Honor. Why? For what reason? I think if Your Honor is going to maintain Your Honor's ruling that these messages will not come in, and the meet and comfort that Mr. Agnifilo is proposing is just about redactions, I don't know that there's a right to be heard. If, however, Your Honor is holding that ruling in abeyance after Mr. Agnifilo's request that we confer, I think he would have a right to be heard. I made my ruling. It seems like maybe people don't understand. Not only is there no basis to omit these
specific messages. But the whole point, the real practical point that I want to make, maybe we're not on the same page, is that there is no issue here as far as I can tell, because the actual examination of witnesses is not being impaired. The admission of 99.9% of the evidence here is not being impaired. Even as to these specific messages, whose probative value is minimal, if any, the government has agreed that these could probably be redacted in a way that even those messages could be put in. So there's simply no issue here, as far as I can tell, in addition to the other legal infirmities that I've addressed. Am I wrong about any of that? I don't believe so, Your Honor. Just to address it right now, because of the nature of Rule 412 and what it actually covers, even if you were to just redact particular words in these messages, that would be sufficient, because at that point, the evidence would just go to the communication that was going back and forth and the fact that those communications happened. So these are simple redactions that technical staff could probably do in about 20 minutes, 30 minutes this morning, and then there will be no issue, right? I think that's right, Your Honor. We need to look at each message. I think if we could remove any references to actual activity, there would be no 412 issue. The court, because as pointed out in cases like Olden and cited by the defense, etc., there can be inquiry to parties agree to establish there was a relationship, and that's covered by the parties' agreement. You can't even specify that the relationship was intimate in nature, right? None of that falls within Rule 412. I think that's absolutely permissible, Your Honor. It's beyond anything we object to. Mr. Agnafilo, you heard that? There should be an easy way to resolve this on a practical level. But I understand what you said before, which is you're not waiving your objection. You're preserving your objection. I hear that. Thank you, Your Honor. We will endeavor at breaks to reach resolution. With that, Mr. Wigdor, is there something that you want to raise? Yes, Your Honor, briefly, I know there's a jury that needs to come out, Your Honor, Doug Wigdor for Cassie Ventura. Your Honor, I think the only issue that I have is I'm the only person who actually represents the victim who has standing under Rule 412, and I appreciate Your Honor's order. But in terms of the meet and confer, I should be part of that. I've already gone through the vast number of documents that have been provided to me. It was not in conformity with Rule 412, which had required the defendant to provide the victim with actually the exhibits and what they were going to be offered for. But I went through them and I isolated many instances that I believe would be in violation of Rule 412. And so the government doesn't represent Ms. Ventura. I do. And so I want to make sure that whatever is decided, that I'm part of that to make sure that Ms. Ventura's interests are met. Ms. Comey, the letters that were circulated overnight, has Mr. Wigdor been furnished a copy of those? Yes, Your Honor. Mr. Wigdor, you now have the universe of the exhibits that have been identified that implicate this issue. I do, and I went through them into the early morning hours, and I've identified in a chart, frankly, all of the sections in those exhibits that I believe will be in violation of Rule 412. I'm happy to share that with the defense and see what their position is. The burden is on them to share it with me, not vice versa. Hold on. Putting that to the side, you heard my ruling. I did. Do you have any issues with that ruling? Because we have to move these proceedings along. You have the exhibits. You've heard what we said. You've heard this entire 30-minute discussion. Is there some part of it you believe does not address the Rule 412 issue? Because I think I covered everything. Let me know. The only thing that I would say is your use of the phrase intimate in nature. I'm not exactly sure what defense counsel believes that means and what questions could be asked of Ms. Ventura under that scope. I think that's the question. It was a romantic relationship. In fact, it was intimate in nature. Isn't that right? And that's it. I'm not going to constrain Ms. Estavallo, for instance, in terms of the particular verbiage, but I don't believe she's going to be getting into the ground of 412 talking about specific actual conduct or actual predisposition. If it's about the general topic of intimacy, it will be fine. Look, I will be policing it, so don't worry. And the government is going to be policing it too. I don't think the rule requires it to be specific in nature. I think innuendo is covered by the rule. And so I want to be very careful that Ms. Ventura's interests are protected. If an issue comes up, you can raise it and we'll address it, okay? Thank you, Your Honor. Your Honor, I need to correct the record. I apologize. There were some exhibits that the government flagged, I think around 2 in the morning, for Your Honor, that we have not had the chance to send to Mr. Wigdor, where we identified 412 issues. So we will get them to him. That's what I wanted to note. Understood. Separately, the other evidentiary issue that was raised, Ms. Slavic, are you addressing that? I will be, Your Honor. Have you had discussions with the defense concerning that issue? Not at this point, Your Honor. As we noted in the email to the court early this morning, given the timing, the government did not have the opportunity to meet and confer with defense about certain of the government's objections. So we'll just take that up as it comes. I suppose so, Your Honor. You've seen the exhibits. That's right. I have your email. I can access all the exhibits. Are there particular ones that it would be productive to address right now? You might get the high sign from Miss Estevallo that don't worry about these, because at the very least, they're not coming in today or this morning. That's right. And to be clear, defense did identify a couple dozen that they do expect could come in this morning with respect to those particular items. Besides Defense Exhibit 1380, the government believes defense needs to identify a non-hearsay basis for each of those exhibits. These are in the chart in your email. That's right. All right. Excuse me. For each message that the defense intends to enter, Your Honor, I'm happy to. So you've raised the objection. So who's going to be addressing this from the defense side? Your Honor, as Mr. Agnafilo flagged, these messages will all be admissible for their effect on the listener and state of mind. I think it will be burdensome to go message by message. Generally speaking, that's what we're talking about. Exactly. Meaning you're saying that, and to be very specific about effect on the listener, to demonstrate what I understand. If you're here in the building, you just stepped in on the YouTube side, can you please hit the like or dislike button before you exit? I would gladly appreciate that. Thank you so much. Will not tell me who you are over on YouTube. It just says that someone liked or disliked the video. All right, it is for engagement. Free way to support the show. So with respect to Mr. Combs' state of mind, it's his understanding of Ms. Ventura's willingness to participate in the actual activity. And with respect to Ms. Ventura, the effect of his statements on her are relevant to the trafficking charge, and that it goes to force, fraud, or coercion. There will be many, many messages that reflect the state of mind of the person sending that message, because these are text messages sent in real time. Ms. Slavic, there you have it, Your Honor. And with that, I will say these are going to come up, and you may have particular objections that that rationale that was just expressed does not apply to a particular text message or text message chain that is introduced. That may happen. Can we make now? Are there particular messages that you think would not be consistent with that rationale offered by Ms. Estevallo? Your Honor, my colleagues are looking through these exhibits now. Let me bring up 2 points. First, in response to Ms. Estevallo's observation that going message by message is burdensome, it is. However, that is a defense obligation to get in this sort of evidence. The obligation is to go message by message. This is why the government needs exhibits like this well in advance, so that the government can pour through the messages and identify any objections that it has prior to the morning of a cross-examination. This relates to my second point, which is a broader point about how this trial is to proceed. The government understands that we should have raised with the court when defense only produced 4 exhibits by their exhibit deadline. I think it's fair to say that the government regrets not bringing that to the court. However, what happened last night is that the defense dumped 400 exhibits on the government. So I guess they were saying, we have 4 exhibits only. 4 times 100. Child, what? Talking about trial by ambush? And they have to go through each text message separately? Come on, y'all. This is beyond playing dirty. is playing dirty. Child. So some of these exhibits were incredibly long. There were documents, proposed exhibits of 100, 200 pages. Many of these documents were internally duplicative. In other words, there were several portions of the same email exchange or text message exchange. Child, they playing dirty over there. They playing. Many of these documents that were marked by defense either substantially or entirely overlap with government exhibits, which were debated between the parties, and all objections or Rule 106 objections should have been raised at that point. This sort of dump of 400 enormous duplicative documents, this is high inefficiency. You are looking terrible right now. The defense is looking, this is horrible for the defense to be brought out. For this to be brought out in open court. Child. This is crazy. 400? You said you had 4 exhibits and you dumped 400. Child, y'all. This is not a good look for the defense. I'm just saying. So the government submits, there really needs to be a solution so this doesn't continue happening through the course of the trial. Ms. Estabio, Your Honor, as evidenced by the fact that there are duplicative messages in the defense exhibit, just shows that we have been working tirelessly to mark exhibits in the past few days and in response to Ms. Ventura's testimony. What's up for always? Thank you for coming. We are in girl. We trying to get to the cross-examination of Cassie. So what I just read, if you didn't hear, right? So remember the defense said they only had 4 exhibits to submit to the court for Cassie. Girl, why they got 400? They dropped 400. 400 enormous duplicative documents on the government the night before. No, don't worry about that. Allie will be here. Yeah. Allie, I know. I already know. It is that like I told you, we were working on documents 4 and 5, or when I sent the transcripts 4 and 5, and when I sent I sent something to the other YouTuber that has the that we have all come together to get the official transcripts. So like I said, because they're expensive, not kind of, they are expensive because it goes by the day. I had went to sleep, and late last night he had sent me over the transcript. So anyway, and you didn't hear, so I'm going to just mention it briefly because I'm not going to be here. I only have I have a little time, so we should get to part of her cross, but I'm definitely going to go live tonight unless something unforeseeable happens. Girl, did you keep? So remember when I said I talked about having a platform, being responsible on your platform. You're covering this case. You have to actually stay on top of what's going on with the case. They charge by the day. So it's $300 to $500 per day. So for all of day 1, it's $300 to $500. All of the next day is $300. So he lets us know how much it's going to cost for the transcript. And then, we take it from there. And we don't, it's only a handful of YouTubers that are, donating to this fund right now. So we kind of take it from there. One person just gets the transcripts and he sends it to, the people that have donated to the fund so that we can, do our own content. Or reading of the transcripts. So yeah, it's per day. Day 1, 3 to 5. Day 2, 3 to 5. Day 4. Yeah, it's just that's what it costs. So Let me just tell you this real quick, and then I'm going to jump back into the transcript. Listen, remember I kept saying people have to be, and I've said it more than once, even outside of this case, but I did say specific to this case. You have to be mindful of what is going on in a courtroom. And definitely, if the court is allowing someone to testify under a pseudonym, and you happen to know who that person is, or you find out what their real name is, it is your responsibility not to dox them. Remember I said that? I said it, right? How about yesterday? The courts have now banned 3 content creators. So the one that I was talking about initially, I don't think she's one of the 3. But anyway, she needs to edit her video and take that mess out, because it's at the very end of this video of hers. But I'm gonna mind my business. I'm not reaching out. You never know how somebody gonna respond and say, listen, hey, this is what's happening. And the reason why I know it may not be her is because one of the persons are from Twitter. It's a content creator on Twitter that actually doxed Mia. Doxing is putting her real name up, putting her picture up. You should not, the way they said she had her hair, you could not really see her face. But people that have been following this case, they know who she is. And people went out of their way to dox them. So now there is 3 content creators that have been banned from the proceedings. I heard they don't even want them on the court property. Nobody's saying who they are. I saw one content creator kind of like allude to it being a certain content creator. I haven't watched any of the proceedings yet this morning, since I'm going live in the morning, because, you know, my mother's schedule kind of like switched around, like for Tuesday, Wednesday, and Thursday. So I will be going live in the morning, so long as everything is progressing the way that it's going. But I just have to be there when she gets home. So that's why I'm going live in the mornings. They've alluded, but I don't have anything that's concrete. And you see, Tisa's not telling who it is. I think it's so messed up that people are, and they're not realizing that they can be brought up on charges. People have emailed the court to say that Tisa doxed her. Tisa did not dox her. She specifically said she knew who she was before all of this, and she specifically said, I am not going to be telling who she is. And she also has her full, like, she has more information on her. So I don't know why people don't believe. You can see when she's on live that people stop her to update her. Did you hear so-and-so? You left the courtroom, it seems, before they said this. Did you get that? The people walk up and people tell her stuff that, like, they like her. But for somebody, and I believe I know which content creator it is, that emailed the judge, because these are the type of games that he plays. That's why I do not play around with this guy. Now, you can be brought up on charges for falsely sending something to the courts, stating that she doxed Mia. She's not one of the people that doxed Mia. They know who doxed Mia. They have the people's channel handles. They have their real names. They have their pictures. And they've already been told. I heard one of them was told yesterday, you gotta go, you can't come in here. You can watch the trial or hear about the trial from anywhere, but you can't hear it here. And the court, the government may take some type of action. They didn't say yet, but they may take some type of action. So what they did was made it bad for the people that are really interested in this case and really wanting to see justice served. So now when it relates to, because Jane, which is another victim, she's victim number 2. She's victim number 2. Gina was victim number 3. She's either victim number 2 and victim number 4. Mia, it was either, or vice versa. Mia was victim number 2 or victim number 4. Mia was a victim as well as an assistant. So that's when I said you have to be responsible with your platform. You have to be responsible with your platform, because this is just crazy and ludicrous that you could be brought up on some charges. This is interfering with a government case. And people just, the daughter was all laughs and giggles. It's not. It's not. It's not a game. Yeah, Tessa, you know, Tisa tells that that's just, you know, share her platform with some of these very same people that, you know, and, you know, it's sad that, you know, moving forward, she may not share her platform with others because of stuff like this. It's just crazy. But I just wanted to fill you in on that. I don't know if you had heard or not, but I just wanted to fill you in on that. Ali, don't put that in the chat. Well, I already know what's going on, girl. We already talked this morning. Well, remove that. Sorry you late. We don't want to hear that. Aaliyah's first. Listen, Aaliyah's first. So yeah, but this is what I said. I said this. You have to be responsible with your platform. You can't just be out here reporting stuff all willy-nilly. So yeah, I hope that the government doesn't go that far and bring charges against these people, these content creators. You cannot. And then to try to put it on Tisa is crazy. When Tisa said she's offering $10,000 to anybody that can go to her page and find a video where she said Mia's real name and gave Mia's picture. I remember her specifically saying, I know exactly who she is. I know her T. I'm not jeopardizing the government's case. I'm not doing it. She was like, I may hint around, and she was like, nah, I'm not even going to do that. So whoever lied on Tisa said, look, they asked her something, she going to tell them, whoever sent you that, lied to the courts, please deal with them legally. Handle them legally. But it wasn't Tisa. It's two content creators on YouTube. One is from Twitter. I told y'all. But I'm going to just stay over here in my little lane in my bubble. I'm a small content creator. I'm going to stay over here in my lane in my bubble because I could, you know, reach out to, I'm sure she heard already, to the person that I saw dox her and say, you know what? You might want to take that off the end of the video. And the only way you might have gotten away with it right so far is because you didn't put in your title assistant something was hammered by Brian Steele. They may not have, but they're watching everybody that's reporting on Diddy, and your video you wasn't reporting on Diddy in the way of the trial, but you do have that at the end of your video. You might want to remove it before they, you know, before somebody, because it is disheartening, and it's very sad the way these YouTubers are against each other. They try to pit each other against each other, and it'll be the person that you least expect, that somebody that you may rock with, that is just dirty, just down low and dirty, that may send something to the courts and say, this content creator doxed Mia as well. Here's a timestamp. Like, I don't even have time to play all those games. It's not even my character. It's not in my character. That is extra work that you have to do. Something has to be wrong with you. You have to be diabolical. I just saw it, and I'm just verbalizing it out loud that, yeah, I saw it, and I was like, oh my goodness, did she just put that up there? And went further in the commentary. Yeah, that's the B-I-T-C-H right there. Her real name is blah, 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 blah. That's a picture right here. You might want to cut that out your video, girl, because the government is not playing. They're They're not playing. And the DAs, they have taken the gloves off for always. I promise y'all, I'm going live later. We're going to talk about that later. But they are not happy about the way Brian Steele humiliated Mia on the stand. And they have come up with a possible solution to rehab her testimony. And guess, child, it's going to all be done. I'm going to just say it here, and then we'll talk about it later. It may all be done through. Now they're introducing the wiretaps, the phone calls made by Puff Daddy, a.k.a. Sean Combs, a.k.a. Puff Daddy, Diddy, Daddy's house, Poppy, Love on top, Tucci on the bottom. They want to introduce his jail phone calls because they corroborate Mia's testimony. Got to be more careful. When I tell you that they have 6 female prosecutors for the United States, when I tell you they took the gloves off yesterday, they took the gloves off yesterday. They took the gloves off yesterday. They said they wasn't going to do it, but since Brian Steele went so hard and went above and outside of where he should have went, they have evidence to prove Mia's account of what she testified about on the stand. Because Brian even took it a step further as to, he was going so hard at this witness to say that there was no abuse at all of anybody. How the heck are you going to get up there and say that and try to get her to agree to that when the defense has already conceded? They have already said Diddy is guilty of that. So yeah, it went down yesterday. Now the government has taken the gloves off, and they like squabble up. Let's go. Squabble up. Let's go. We want to introduce these phone calls by the Diddy in the court. We want to play them. Child, it is getting, and the bribery. Mr. Eddie Garcia, the person that took the $100,000 bribe, got straight from Diddy. He got the money straight from Diddy. Diddy, you on the phone with this guy? They got his personal phone number. He doesn't know how, but Diddy paid him the money. And the NDA was on paperwork with Bad Boy International on a letterhead. On Bad Boy International letterhead paperwork. God daggone it, you should have just took the deal. Because, baby, they done brought your CFO in there. The $20,000 that Cassie's mother wired into the account. Right into the Bad Boy International account. The CFO brought the paperwork. Baby, when I tell you it is heating up, it is heating up. Jane is testifying today. This is why. The government has already proven their case, really. It's just that there's some people just not understanding. They're not understanding. And I heard something yesterday, but it hasn't come from the court, so I'm not going to repeat that. About a crew that they had in New York. I'm not going to repeat that. I'm just like, really? Oh, wow. I didn't know that. So I'm not going to repeat that. I don't repeat stuff just because, but oh my gosh. Child, he should have just took the deal. You should have just took the deal. Now y'all trying to say that no abuse happened. What is it going to be, defense? Were these people abused or not? And then the person that he dangled from, Cassie's friend who wanted to be a fashion designer that he dangled from the balcony, she's supposed to testify as well. Child, I can't make this stuff up. The CFO brought the paperwork in there. The 20,000, they showed the 20,000 being wired in. So the CFO probably said to Diddy, "Are you nuts? Do you know that this could? But you need to send this money back." He could have said it. He didn't say that he did tell him. I don't think they asked him. I can't wait till we get to that transcript. But 4 days later, you see it go back. Does that change the fact that you already extorted me? No, it does not. You extorted me. You extorted this lady's family out of $20K. They had to take out a second mortgage on their home to come up with this money. Diddy. Did he do it? Child, it was just a mess. Let's get back to them saying, y'all, I know y'all all remember they only had 4 exhibits. They go ahead, they drop 400. I can't make this up. It's in the official transcripts. Oh my goodness, Lord. So anyway, so where do we start? So I'll say, so this is an argument that Miss Estavio, she's from the defense, is trying to make about these transcripts. Your Honor, as evidenced by the fact that there are duplicative messages in the defense exhibits, just shows that we have been working tirelessly to mark exhibits in the past few days and in response to Ms. Ventura's testimony, and we do not anticipate introducing all 400 of them. But you were hoping that the United States would be like, oh, what, overwhelmed and okay, and say whatever. But they're on their game. They're on their game. Oh my goodness. So why did you send the 400 duplicative exhibits? A lot of the exhibits that the government had already sent to them, child, it is just they're trying everything and it's just not working for them. That's probably why Rico left. And Rico was not the Rico charge. It's Rico the attorney. They said he's a dang on good attorney. He probably saw something and didn't want to stain on his name. But Rico hasn't made a statement right about now. So what that is right now is just them people are just speculating until Rico makes a statement stating why he left. We can't go by what people are speculating. But anyway, many of them, in fact, are marked simply for identification purposes so that we can refresh our recollection. That's dumb. Something to that effect. And we also marked based on the anticipated testimony from Ms. Ventura before we knew what her testimony would be. And so they're over-inclusive in that respect. And we gave the entirety to the government. Yeah, the day before. I'm happy to flag the first 20 to 50 or so that I intend on using if that will make things easier. Let me take a step back. The court says, let me take a step back. Mr. Agnifilo, I thought you were going to take this off. You said you were going to take this off my plate. He sure did. Yeah, did he say that? Tell him, Judge. I take it the parties have not come to an agreement as to how disclosures will be made. I think taking it off your plate, Your Honor, is going to be a day-by-day process, and I'm going to continue to try to take it off your plate as the morning goes. I am. Ciao. First of all, this is far and away the biggest witness in the case in terms of the volume of materials. There's no second. I mean, this witness stands by herself. It's sometimes typical, but a little unfortunate before the trial, kind of gets into the rhythms and patterns that trials sometimes do. We had this witness early in the proceedings. Yeah, and we're glad they had her early in the proceedings. Come on now. We all know what game y'all was really trying to play. No. So that all being said, we've been literally doing this all night until 3 a.m. So we're making duplicative, child. Y'all making it worse. Y'all need to just sit down and shut up because you sound stupid. You sound stupid right about now. Oh my gosh, which is why we flag for them that these are the ones we really think are actually going to come up. Forget about the 400. No, you dropped 400. So let's not forget about the 400. The court needs to know that you dropped 400 exhibits on them and you said you only had 4. No, let's not forget about it. Let's keep letting the court know. That's so we don't mark something. Put something in to refresh her recollection that we didn't give you. And then that's the problem. So we're doing the best we can. We're working with the government actually fairly closely. Really, y'all are when it benefits you. But this was going, y'all was trying to conduct a trial by ambush, and that's what this is. That's what they were trying to prevent. Hence the reason why we've been here over 30 minutes arguing this back and forth. They're embarrassing themselves. And poor Brian Steele. I'm not going to say poor Brian Steele. Brian Steele is a great attorney. And this is why you have to pick and choose the cases that you take, regardless of the money. I'm sure there were other cases that you could have been on, Brian, but you chose to come here and play with the diddler. All right. So what we will do and what I will do to try to take this off your honor's plate on an ongoing aspirational basis, we don't care how many big words you try to use or how you try to make what you're saying colorful. You already said you was going to take it off his plate, and this is the disaster that they ended up with. All right. Hopefully one I will meet is we will give the government an idea of what's going to be coming up this morning. We'll work over the breaks to do the same on an ongoing basis, on a going forward basis, so the government will know what's to come. And part of the problem, and this is a conversation I had with, I think it was particularly with AUSA Comey. Okay, did you really? Because she just came on here and you said something and she just came on here and basically told the court how you was lying and exactly what happened and exactly what was said. Gave the dates and everything, sir. This is hard. This is terrible. Did he pay how much money for these attorneys? Child. I said in other cases, what we've done is we've given the defense materials even before the direct was over. If the prosecution team agreed to not prepare the witness on it, why are you going backwards? We already heard this, but y'all keep saying that they are, and that's why they are not giving them the exhibits. Child, stop. I think the concern of this prosecution team, and I respect the concern, quite frankly, it's hard to unknow something. That's right. So the evidence y'all trying to get in, once the jury in the public hears it, it's hard for them to unhear it. Yeah, didn't he? That's what he's saying, right? It's hard for him to unknow. And so maybe they wouldn't show it to the witness, but they would know it, and that would have some effect. Do that make what do? Do that make sense? Yeah, like I can't be the only one like sitting here like confuzzled at this point. I can't be the only one. I cannot. I can't. Oh my gosh. So I am trying to solve this. The court cut him off after he said that. He said, the court says, at the very least, if you intend to put in exhibits the next day, you're going to disclose them. We talked about that yesterday, and that's not going to be a problem. So, Allie, for always, I just want to let you know. So you see the QR code that is on the screen. Somebody, because Allie, you asked about the other day, and I'm sorry, I'm just jumping in, just about to want to let you know. That is a cat. If they use their phone to hover over that, remember the other day, Flesh said it wasn't working. It does work. I tested it. I haven't changed it. Haven't done anything. I tested it with my phone, and it went directly to the Cash App. If one of you guys can just test it to see if it opens up for you, because I'm just like, I didn't know it wasn't working, or maybe it could be something with the phone. You don't have to send anything, just see if it opens up to my Cash App. I want somebody else to test it because I tested it already. Thank you. At the very least, so the court cut him off. At the very least, if you intend to put in exhibits the next day, you're going to disclose them. We talked about that yesterday, and that's not going to be a problem. So it worked out. I think it won't be a problem. It worked out. Child, he's still trying to hold on to their failures. So what I don't want to do, because I've spoken to the government about it, I said, if we give you guys stuff during direct, and you can assure you direct, can you assure me you're not going to prep the witness on it? They said they won't show it to the witness, but we can't unknow it. What? What? So I respect the answer, and it's an honest answer. What I can't allow us to be in the position of doing is to flag our defense theory in terms of the exhibits. So what are you going to do? For today's purposes, the scheduling accommodated disclosing these exhibits last night. Yes. 3 binders worth of information, which I've gone through hundreds of binders of information. So 3 binders is doable, but I understand the concerns here. But as to other witnesses, there may be a direct in the morning and then a cross-examination in the afternoon. So you should just be thinking about how you plan to make disclosures in that context, so we can address any issues ahead of time. He says, and I will. And I think the information falls into different buckets. I think there's certain things that the courts that talk about the Rule 16 obligation, the defense case in chief being part of the cross. I think that stuff is usually a much smaller universe. You're saying that if I were to say that the disclosure should be made the previous day, but that those exhibits that you'd be turning over, which would solely be the affirmative evidence on the part of the defense, could not be used to prepare government witnesses, then you'd be fine with that. You do it. Is that what you're telling me? Your Honor, anything Your Honor orders me to do, the court. I'm saying that would be something you're saying happened in a prior case. Yes. Though. Yes. And anything the parties can do by agreement, I can do by order. Right? Listen, right now, I'm loving on Judge Aaron. His last name is too long, so I just got Judge is respectable. Aaron. I hope that I'm saying his first name right. So no question. Let's do this. Let's get past this witness. Look at Mr. Agnifilio. You try. Listen. You want to be a judge of a court. You want to be the referee. Go on ahead and see if that's what you can do. Go to get your schooling for that, and that's what. How you, child? Really? Why would I try it? All right. I'll work on that later. Let me remove it. I don't know what's going on with it. I don't know. I did it and it worked. So anywho, I'll think about that later. We got links. Hopefully they working. So anything the parties can do by agreement, I can do by order, right? So he says, no question, let's do this. This is Mr. Agnifilio. Now you want just to be taking over the courtroom, boy, sit down. Let's get past this witness, which I think presents a universe of issues that we're not going to have with any other witness, and we will work this out. I will continue to do my best to try to take this off the court's plate. The court's plate. That is good. Your Honor, just a couple of reactions. First, a practical point as to today's cross-examination. There are still several dozen, at least 24 exhibits that the government does have objections to. They're noted in the chart. But as these exhibits are presented and potentially as the defense seeks admission of these exhibits, there will be many sidebars to resolve these issues that could have been resolved earlier. So, Your Honor, the government asks, just the ones in the chart, those are the ones that the government understands may be used before the lunch break. The court, just help me with the nomenclature here. So you say, for instance, hearsay overlaps with GXB 336, and then there's a Perrin Wade 106 objection. Right. What does that mean? The hearsay objection. You understand that? Ooh, wait a minute, Miss Lavin. Now she's from the prosecution. With respect to the language overlaps with Government Exhibit B336, the point there is that the Defense Exhibit 1001 has overlap with an exhibit already in evidence. Government's point with respect to that is the government identified that Government Exhibit 336 in this case, and the parties dialogued about whether the defense had any objections. And the defense, in fact, provided 106 objections and sought to expand those text message exchanges if they had a rule of completeness objection. The government's position is that in remarking a different portion of that very same text, they've waived any sort of 106 objection, and on what basis? They should be precluded from offering that exhibit, Your Honor. If they have a basis for getting that exhibit in, what does that have to do with the 106 issue? Because 106 says, help me if I'm wrong about this, when you're putting in an exhibit or statement and they are putting in a completing statement, that comes in at the same time. And so that's why they're doing it in that way, because the statement can go in without the completing statement going in. But is there some authority that says that then waives any effort to independently put in a portion of that document that is not being offered as a completing statement, but is independently admissible for some other reason? Your Honor, the government's concern is efficiency, and confirmed with the defense about the government exhibits that was resource and time intensive. And to have to do that process again is simply a waste of resources. It's incredibly inefficient. Understood. So if it's efficiency, then that ship has sailed by the fact that none of these things were addressed in advance. That's what I'm trying to figure out, if it's an efficiency issue or a substantive issue. If it's a substantive issue, I think the substantive issue that's identified of all of these exhibits is the hearsay issue, which Ms. Estevallo identified the basis for the omission of these documents. So I know that now. So when she tries to admit these exhibits, you will raise an objection if you have one. I will look at the exhibit. If I need a sidebar, we'll take one. Otherwise, some of these are just 2-3 pages, and I should be able to look at them and figure out whether the objection is sound or not. Some are quite short. Others are not short. I also want to note for the court that when defense presents a different portion of a government exhibit that was presented yesterday, that's potentially confusing to the jury because the government offered those exchanges. That exhibit for the truth as opposed to the purposes of defense offering the text messages. Your Honor, getting back to the concern, the government requests that the court order defense to turn over exhibits that they intend to admit as they mark them. If you're just jumping here on the YouTube side, please hit the like or dislike button and subscribe if you're not subscribed. It's a free way to support the channel. I know you may have to run, and thank you so much in advance. So okay, so I think what happened last night really shows that there's no strategic advantage. Turning over 400 documents is not giving the government a strategic advantage into the defense strategy. This is purely efficiency. This is for the smooth running of the trial. Just to be clear, the reason that the government doesn't feel that it can commit to not showing defense exhibits to witnesses because, as defense has repeatedly said, these exhibits come from the government's discovery. So it's entirely possible that the government is showing that what's marked as a defense exhibit to the witness in the normal course of witness preparation. So I don't think that the government can comfortably make a representation that it will not show defense exhibits that it might already be showing those witnesses. I don't think Mr. Agnifilo is concerned with that. That's what he said. In the course of witness prep, if they have a stack of documents that they're using on a witness, and it happens to be some of these exhibits are also in the pile that you provide to the government, you're not saying that they can't prep witnesses on those exhibits, right? I'm not saying that. You're saying that you have other things that you are identifying. That's one category. You can't prep the witnesses on those other things. Separately, if there are exhibits that the government didn't know of and they see it in your stack and they go run and find them and haul them out and give it to the witness, that would also be improper. But I don't hear Ms. Slavic saying that's what they're doing. I don't hear her saying that's what they're doing either. What I heard the government say, and like I said, I appreciate the candor, is that if we were to give the government a certain number of exhibits, they would know what's important to us and might conduct some type of witness prep accordingly. These are not the issues. We will figure this out. You just saying the same thing over and over again at this point. I'm tired. Move on. The court, you told me that yesterday, and I'm pretty sure I said it needs to be figured out yesterday. I know it was not figured out, so I'll give you a grace period. That if it's not figured out before the lunch break, so while you're there, try to figure out a workable solution. Talk to the government, because we're going to just end this one way or the other. I've heard Ms. Slavic. I've heard you. It's now 9:31. I promised the jury we would bring them out at 9:30. We have a timing issue that we need to be very cognizant of. So last word, Ms. Slavic. Just the very last word. It sounds like a lot of the evidence that the defense will offer, they'll seek to omit for the effect on the listener. Yes, the government just requests each time a limiting instruction that those statements are not being omitted for their truth, but for the effect on the listener. Mr. Agnifilo says, I guess it depends on the actual basis of admissibility. If it's omitted under 803.3, it would be offered for the truth. If it's being offered solely for its effect on the listener, then that's a different story. I would object to the court the court cut him off. I am not going to be giving any limiting instruction on that basis. If there is a particular reason for a limiting instruction in a particular circumstance, a sidebar can be requested and we could address it. Very good. Your Honor, I think that's going to confuse the jury. How is it not the situation as with any document or exhibit that the government seeks to omit that is hearsay, but not? That could be hearsay, but it's not offered for the truth of the matter. The court does not give the jury a limiting instruction in each instance. Rather, the way in which the evidence is used is indicative of the purpose for which it was put into evidence, and the jury will understand that. If Ms. Estavallo were to suggest that certain things in the text messages actually happened, which would be inconsistent with the reason why they got them in the first place, then you will be heard to give a limited instruction or to strike certain testimony, etc. We could do that. If any time we put in a potentially hearsay statement that was not offered for the truth, and the court would have to give the limiting instruction each time, that would seem to be not the usual practice in any court. If I may, Your Honor, that is what Judge Stein did in the Senator Menendez trial. Ooh, Senator Menendez. And what he did was the first time such a limited instruction was requested, he instructed the jury on what it means for something to be omitted, not for its truth. And then every time it happened afterwards, he would just turn to the jury and say, not for its truth. Just like my last instruction. And it was very quick and very efficient. It's because otherwise, when a text message comes in, a document comes in, any juror would naturally think, I can read this and interpret it for its truth. I can assume it's offered for its truth. It's not intuitive to a jury to understand that a document being put in front of them is not being offered for its truth, but for some other purpose. That's what we were asking for. And we wouldn't have objected if the defense had asked for that when we were offering things for their truth as well. My position, Judge, is Your Honor's initial leaning on this, that if something comes up and the court feels that it's important to tell the jury for this instance, that this is being offered for the truth, that the court will do that. I think it's going to be very apparent from the nature of the cross what this is being offered for. Now, I don't believe that. Now, I do not believe. Huh? No, I removed it for always. It's not there anymore. I took it down because Allie tested it. So she got the same thing Flesh got. So I don't know. It comes up for me, but it doesn't come up. It didn't come up for her. So I removed it. I'll work on it another day when I have free time to see what happened, because it was working. So I think it's going to be very apparent from nature. I think it's going to be very apparent from the nature of the cross what this is being offered for, and we haven't. That's been apparent even in the opening statements. We are not going to transform this evidence into something that it's not. It's about the nature of a relationship. It's about jealousies, and it's about the things that people do and the way people react when they are jealous. Its heartland effect on the listener and not being offered for the truth. The jury is going to hear that in real time because of the nature of the evidence. I have heard both sides. We will take it up at the lunch break. If at that point I need to make some limited instruction, I'll be able to do so. And the number of exhibits that would be at issue would be small in volume, given that there is just about 2 hours worth of time that we have before the lunch break in any event. With that, Ms. Johnson, let's bring in Ms. Ventura finally, y'all. I'm tired. I was tired. With that, Ms. Johnson, let's bring in Ms. Ventura so we can save a little bit of time. I asked the courtroom deputy to make sure the jury is ready. Your Honor, may I approach to give your deputy a drive of the defense exhibits? Of course. Members of the jury, welcome back. I promised you that we would start right at 9:30. I'm only 8 minutes late. I apologize for that, but we are making some progress here. Ms. Ventura, you understand you are still under oath? Yes. Ms. Estevallo, when you are ready, you may proceed. Thank you. Cassie Ventura resumed. So we are going to start with cross-examination. I did tell you that we are probably going to end at a very weird point, but at some point I do have to stop and I have to run. Need to be there when my mother gets there home. So hold on a minute. Let me just do this right now because this is about to happen. So before we even start the cross, let's do this one right here. So, all right. All right. All right, there we are. So we fixed that. This video is not for kids. Trigger warning, trigger warning. Yeah, so she's the schedule has changed a little bit. She's getting back to things that she used to do. So we're testing that out. So that's why on Tuesday, Wednesdays, and Thursday, I'll definitely be going live unless something else comes up for me. We're not ending it yet. It's just that we will be ending it. It's going to be at a weird point, but we're good. So, good morning, Miss Ventura. Good morning. You and Sean Combs were in love for 11 years, right? Yeah. Just get right on into it. Why don't you? Just let us know. Come on now. Just let us know. During that time, you loved him. I did, yes. And you believed that he loved you as well. Yes. And during those 11 years, you took care of him in the ways I could. Yes. And you believed that he needed someone to take care of him. She said, I don't know. In some ways, I guess, yeah. On direct examination, you used the term larger than life. Do you remember using that term? I do. From what you could see, to many people, he was larger than life. Yes, not just to you. Come on, I'm sorry. Oh, just wanted to make sure my batteries didn't. Okay. From what you can see, to many people, he was larger than life. Yes, not just to you. Yep. But to you, he was Sean, right? Yes. And that's the name that you used the past 2 days in the courtroom, right? Yes. That's the name his mother gave him. Objection. Withdrawn. Child. He might have used other names for other people, Puff Daddy, P. Diddy, but you called him Sean, right? You forgot Pop. Oh, you know what? That is what she is trying to Oh, she is trying. Remember, she said that she called him Pop Pop because they wanted to come up with a nickname, and he asked her what is the name that she used to call her grandfather, and she said Pop Pop, and he told her to call her Pop Pop. Oh, they think they slick. Yeah, y'all forgot Pop Pop. Y'all forgot Pop Poppy. Y'all forgot all Love on top, Tucci on bottom. Y'all forgot Brother Love. So yesterday, yeah, and that's a part of what made your relationship with him special. Is that you knew the real Sean, right? I believe I knew a real version. Yeah. Well, you knew the Sean that other people didn't see. Correct. You knew a version of him that he wouldn't let the rest of the world see. Objection. It's overruled. You knew the Sean that he didn't want anybody else to see but you. Objection. Overruled. Can you repeat? I would have went off here if she asked me this question. Yep, I knew the Sean that pounded on my head, stomped on me, kicked me in the face. I would have went ham on this question. Because, baby, what? You know the Sean that he didn't want anybody. So they said objection. Can you repeat? You knew the version of Sean that he didn't want anyone else to see but you. Say the other people that were invited into this relationship. Can you rephrase that? I'm sorry. You knew of a version of him that the public didn't know, right? Correct. Yes. And that many people in his circle, in his world, didn't know. Yes, that's fair to say. Even his family didn't know. Yeah. And you knew, and you always knew how special you were to him, right? No, I don't think I always knew. You sometimes knew. Sometimes it's fair. You frequently knew. Sometimes. And that's why it hurt so badly when he lied to you. Yeah. And when he cheated on you. Yes. And that's why it hurt so badly when he promised to tell the truth and be faithful to you and then let you down time and again, right? Yeah. You said on direct that you were very jealous. I think insanely jealous is the phrase you used. I did. And he gave you a lot to be jealous of, right? I mean, it's all relative. Yeah. But for 11 years, you put up with that jealousy, right? Not the whole time. No. You were on and off during the relationship. Yeah. But you kept coming for 11 years. I wouldn't use the word coming back. You would continue to get back together with him for 11 years. Yes. Despite his imperfections, his maybe not strong enough. Yes. His flaws, right? Yes. We are going to talk about all of those. That's because you loved him, right? I did. And for those same 11 years, you put up with all that because you believe that he truly loved you too. I did believe he loved me too. And because you were so in love with him when he cheated on you, it really hurt. I would say not every time. I see. But did you spend a lot of time feeling very hurt during the relationship? I would say in the early stages, yeah. And I want to go back many years to the beginning of your relationship. You fell in love very quickly, right after your 21st birthday. Yes, it was very quickly. And the early part of your relationship was filled with love and passion, right? Yes. Can we bring up for the parties and the court defense exhibit 1353, please, and the witness? Do you recognize this communication, Ms. Ventura? I don't. I am just going to read it. Do you recognize that email address at the top? Yes. That's an old email address, I assume. Yep. This appears to be an email from you to Mr. Combs, correct? Yes. Can I read through it? We are going to read through it. I'm going to move for its admission at this point. Any objection? Yes, Your Honor. We object to the top two messages for hearsay. They appear to be offered for their truth. Response. This is offered for state of mind and effect on the listener, Your Honor. Your Honor, based on the examination so far on its face, it appears to be offered for the truth. Ms. Estevallo, why don't you ask some further questions, and then we can determine whether there is a basis for admission on the grounds that you've indicated. Ms. Ventura, can you read the first two messages? Objection, not in evidence. That's true, not in evidence. Read to yourself. Would you please read them just to yourself, Ms. Ventura? From the top or the bottom? From the bottom. Why did you send this message, Ms. Ventura? I was just communicating with him. It looks like letting him know I was going to dinner. One moment, Your Honor. Ms. Ventura, what was going on at this time when these messages were sent? I'm not sure, honestly. What was going on in your relationship with Mr. Combs at the time these messages were sent? This was like early in the relationship, but I'm not like specifically sure of like that date. And what sort of messages would you and Mr. Combs exchange during this time period? Loving? Yeah. Would you exchange messages on a regular basis? Yes. And would you update each other on what you were feeling and thinking at the time you sent the messages? Yeah. And would the messages that you then receive from each other be read and reacted to? Yes. I would offer it at this time. Your Honor's same objection is clearly being offered for the truth. Overruled. Can you please publish to the jury? Can you read the second message from the top out loud? Ms. Ventura, this is from Mr. Combs to you. You want me to read out loud? Yes, just the text of the message itself. It makes me so happy that you will fly to ALT. I guess it's just to see me. I'm truly a lucky man. I love you, missing you. Can't wait to hold you. Now, could you read your response at the top, please? I'm a very lucky woman, smiley face. I'm a very lucky woman. I miss you so much. I fly wherever you need me, whenever. I love you, Cass. Thank you. Can you please take this down to bring up just for the parties, the witness, and the court defense exhibit 1354? Can you take a look at this and just read it to yourself? Ms. Ventura, sure. Do you recognize this to be an email between yourself and Mr. Combs in 2009? That's what it appears to be. I'm almost done reading it. We are going to read it out loud. During that time period, would you consistently again send messages back and forth with Mr. Combs? In August of 2009, yeah. To update each other on what was going on and what you were thinking. Yep. And you read and reacted to these emails as you received them? Yeah, at this point. Move for admission. Objection, Your Honor, on a few bases. I don't believe Ms. Ventura has authenticated this document. The bottom, starting from the bottom, that first message has hearsay within hearsay, and then going up to the third message from the bottom and the fourth message from the bottom, and we object on hearsay grounds. That appears to be being offered for the truth. Ms. Estevallo, there are probably a few more questions to ask. You can try to address those objections. I'm happy to only offer the first four messages. We object to the fourth, and we would need to do a redaction prior to publishing or just zoom in on the top, but we will still object to the fourth message, and Ms. Ventura needs to authenticate this document. Ms. Estevallo, Ms. Ventura, does this accurately reflect an email between you and Mr. Combs on August 12th of 2009? For what it looks like, yes, but I haven't seen this message in a while, so I don't. Would BG new pin reflect your BlackBerry pin number withdrawn? Would BG, what does BG mean to you? To me, it meant baby girl. Is that what Mr. Combs referred to you as sometimes? Yes. And did you correspond with Mr. Combs via BlackBerry during this time? Yes. And did you correspond with him on a regular basis via BlackBerry? Yeah. Would you use your BlackBerry to say, updating what you were thinking and what was going on at the time? Ooh, BlackBerry. I heard of that a long time. Yes. Would you read those messages and then react to them? Yes. Move for admission. This portion of the exhibit will be admitted. Your Honor, we maintain our objection to the bottom email. I understand. Can you please publish to the jury? The judge, if you understand why. So can you please publish this to the jury? I will read from the bottom from Mr. Combs' messages, and I would ask you to that you read yours. I love you so much, it makes me cry. And so it has 5 O's attached to it. You hungry, Pop Pop? Pop Pop. She calling him the name that she calls her grandfather. Pop Pop. Child. And that's because Puff Daddy wanted her to call him Pop Pop. After finding out that that's what she calls her grandfather. Sick, twisted, and diabolical. I just can't. You can't make this up. These are the official transcripts, y'all. Nope, thank you. No problem. Let me know. You can take this down, Mr. McLeod. Please just show the parties, the court, and the witness defense exhibit 1359. I didn't understand what I don't understand what that did. Did that really do anything? Yeah, nothing but that is sick. Because if the jury is remembering why she's calling him Papa, child, take the wheel. You can take this down. Mr. McLeod, please just show the parties according to Witness Defense Exhibit 1359. Ms. Ventura, this document does it also say BG new pen in the from column at the top? I see that, yes. And again, BG, would you refer to baby girl? And that would be you, yes. And again, would you frequently correspond on BlackBerry with Mr. Combs? When we have Blackberries, yes. Move for admission, no objection. This will be admitted. Can we go to the third page of this document? Second page. I'm sorry. Our copy has two. Uh-oh. I'm going to read the third message from the top from Pop Pop. You understand that to refer to Mr. Combs, correct? Why he wanted her to call her that? Because he's sick, twisted, in the mind, diabolical. You know, her grandfather, she probably looked at as some type of, the apple in her eye. Like my Pop can do no wrong. All types of crazy-ish. Ain't no telling why. I just think that it's pretty sick. That you asked her, what name does she call her grandfather? She said Pop. And he said, yeah, that's going to be the nickname. Call me Pop. Only this man know why. The exact reason why he had this girl calling him Pop. I can't. Can we go to the third page of this document? Second page, I'm sorry. Our copy has two. So I'm going to read the... So it says, yes. Did it make you miss me? You want me to read the next part? Yes, please. A lot. You didn't even respond to my message. I don't understand why they're reading these text messages. I really, really don't. Can you please take this down and put up Defense Exhibit 1360? Again, this says BG new pen. Does this actually reflect a communication between you and Mr. Combs via BlackBerry in 2010? Yeah. Move for admission, Your Honor. We need a moment to review the document. All right. Your Honor, we object to hearsay grounds. So all the messages except the top two messages on page 1 and the last message on page 2. That objection is overruled. 1360 will be admitted. Oh, Judge, I gave you a chair. Miss Ventura, we're going to read from the bottom up. Do you mind reading the BG new pen messages? Going to sleep now so it can be tomorrow faster and you can be home. I love you. Love my baby. Smiley face. I love you so much it consumes my life. How did that happen? I don't know. I wonder the same thing for myself all the time. Like, who was I before we decided to be together? I never knew it could be like this. How do you have me this way? Laugh out loud. What do you mean? I'm so happy that we fell in love. We are so in love, we don't do anything else. That's not true. But you're going to have to work so hard, 4 times as hard as me, which takes a lot of time. Ciao. I don't think this text message kind of helps him. He's telling her, you are going to have to work so hard, 4 times as hard as me, which takes a lot of time. Basically, he's setting the stage there to baby girl. You're going to have to work hard. It's going to take up most of your time. I don't know why they thought that was something that was good to show. Ciao. Miss Ventura, this exhibit is from April 4th, 2010. At this point, how long have you been seeing Mr. Combs? At this point, I would say like 2.5 years. Mr. McLeod, can you please put up Defense Exhibit 1355 just for the parties, the court, and the witness? Does this accurately reflect the communication between you and Mr. Combs via BlackBerry on August 15th, 2009? May I read it? Yes, of course. Your Honor, this has at least 3 pages. Could we make sure that the witness sees all 3? Mr. McLeod, Ms. Ventura, if you need to see the next page, you can just let Ms. Esteballo know. Is there another page or is that it? Was this all other pages? Because I was supposed to read it this way. I believe there should be a 3rd page. Mr. McLeod, thank you. Sorry, I was confused. That's all. Yes. Is the government still reviewing? Exactly for always. He was brainwashing her. He was grooming her. At this point, get ready for the ramp up. Because if you think what we're doing now is something, when I ramp it up on you, you're going to have to be ready. That's what he's saying. You know, for those of us that are mature and adult enough to read in between the lines, knowing what we know, that is what these text messages are saying. Hopefully the people sitting in the jury box see through it just the way you and I do. Because we are looking at this case, we are reading these official transcripts. We are unbiased. We are basically, listening to the information, and applying it as a juror, as being a juror, not being, from a legal, standpoint, because we're not attorneys, right? We are jurors, everybody, but we are just not sitting in a jury box. We are public jurors, but we are mature. We're able to see context clues. We can see past some bullish. We can see past Diddy being Diddy, the star, the larger than life Diddy. We can see past that. And that's what we're doing. And that's the difference. Yeah. We can see past this bull crap. It is crazy. Okay, so I think the witness is still reviewing. Ms. Ventura, when you are finished looking at it, I think I'm good. Miss Esteballo, does this reflect the communication between you and Mr. Combs on August 15, 2009? It looks that way, yeah. Move for admission, no objection. This exhibit will be admitted. Turning to page 3, the second from the top, beginning with amazing. Can you read that one? Amazing. I love you so much. It made me feel like I can't wait until we don't care anymore. Laugh out loud. What did you mean by until we don't care anymore? Honestly, I don't know. I haven't seen this message in a while, but we definitely were not open about our relationship for the beginning part. Yeah. So basically, she was a secret. Ciao. Can we go down to the second from the bottom, beginning with the subject line, and then the second from the bottom? That says, read my last tweet. You say, OMG. Pop, can I respond or write something about my man? Ciao. Does that help you? Does it give context for what you meant by I can't wait until we don't care anymore? Yeah, it's still kind of the same meaning to me. Go ahead. What you thought it was going to change? Then she was a secret. You're my little secret, and that's how we should keep it. She was a secret. You just because you had to read that part, it doesn't change. She was a secret. For some reason this morning, I feel like I'm kind of dehydrated already. She was a secret. It doesn't change. I'm so glad she hit her with that one. It don't change nothing. What you want me to say, lady? Same thing. Secret. All right. Go ahead. It was about a post, right? So I'm looking. Does it suggest that you're looking forward to being public with your relationship? That I can agree with. Yeah. Because at that time, it was still relatively secret. Is that right? In 2009? Yeah. Why was it a secret, though? That was your song. You're my. No, let me get back. Let me get back. Oh, yeah. It just pops in my head, but because you're a secret. Because at that time it was still relatively secret. Is that right? In 2009? Yeah. How long had you been together with Mr. Combs at that point? I think, like I said, it was about 2.5 years by now, by August. Ain't no measy feeking way. Ain't no goddamn way. None. No way, none. What? Child. Can we go go to the first page, please. The top 3 lines, top 3 messages. What do you say? The third message from the top. Pop, pop. I really miss you. Mr. Combs says, me too, baby. Damn. I can't wait till I see you. What do you say? Me too. While you were seeing Mr. Combs for the duration of your relationship, did he frequently travel? Yes. I don't know when I said me too, why I got this thought, because I forgot to tell y'all that Bryant Steele did bring in the Me Too movement questions with Mia, and that's what a lot of people felt was disgusting. He asked her a question in relations to the Me Too movement. I can't wait till we get to that transcript. Yeah, it was pretty disgusting. When I said me too, I knew it was something. I'm gonna have to start writing down my thoughts. I normally remember them from memory, but yeah, he asked her, why didn't she report something about Diddy when the Me Too movement happened? And that was with R. Kelly. Totally inappropriate line of questioning. Totally disgusting. She did not want to tell her family or anybody else. She was being essayed by this monster. So Brian, that was like really below the belt. And it was disgusting. It really was. But okay, I digress. While you were seeing Mr. Combs for the duration of your relationship, did he frequently travel? Yes. How frequently was he traveling generally? Weekly, I would say. And were you traveling pretty frequently as well? Frequently, not as much as him. Even though you were in a relationship with each other, you weren't together all the time, right? No. In fact, you often had long breaks from each other when you didn't get to see each other, right? Yeah. And he sometimes would have to travel for long periods of time when he was doing something for work. Yep. And the same for you. If you were going to film elsewhere or you had some event, you would not be together, right? Yep. Can we please bring up Defense Exhibit 1364 just for the parties, the court, and the witness? Ms. Ventura, does this reflect the communication between you and Mr. Combs via BlackBerry on April 22nd, 2010? May I read it? Yes, I read it. Does it reflect the communication between you and Mr. Combs? Yes. Move for admission. No objection. 1364 will be admitted. Please publish to the jury. Can you please read your message to Mr. Combs at the bottom? So you hung up? It's like I need to have something written out to say to you with no breathing room, or you'll get mad at me and hang up. I haven't talked to you at all. I know you can take 3 minutes out of your day to talk to me, and you don't even try. You're in too much of a rush to get me off the phone. That's not being in a relationship with somebody that you love and are in love with. I'm really hurt by the way you deal with me. I don't need your money. I need some attention. I am thankful, but I can pay for these things myself. She did have a very, R. Kelly and Harvey Weinstein. She did have a very lucrative modeling career when she first got with Sean Combs, which he kind of stopped. Like, he would tell her what she could do and what she couldn't. And a lot of times she said he would say no more than yes. So, oh, wow. So the type of brands that Cassie would get modeling gigs for, it could be anywhere in the double digits. Like, she can be paid anywhere, like, 10,000, 20K for a campaign. And a lot of people don't think that, models make that type of money. You do. You make somebody's whole salary, or, in one day, or you can make somebody's whole paycheck for a week or two in one day. Trust me, I know. Yeah. So anyway, I'm thankful, but I can pay for these things myself. I believe, maybe that's why he started, telling her, not letting her make more money, because she put it in his face. A narcissist doesn't like that. So I believe you testified on direct examination that you frequently wanted more time with Mr. Combs, right? Yes. And it was important to you to get your special time with him. Yeah. And it was common for lots of people to want to spend time with him, right? Right. He was in high demand, right? Yes. Why is that? Why did people want to spend so much time with him? Objection, speculation. You can rephrase. Why did you want to spend so much time with him? I wanted to spend so much time with him. I mean, at this point in 2010, because I had fallen in love with him and cared about him very much. Yeah, models make big bang. Models can really, you can really make some good money modeling, especially if you're hot. And you know, even though they weren't public, she still people knew that she was connected to Diddy because at this point she was signed to him. But she was making millions of dollars as a model way before she signed to him. She's a very pretty girl. Very, very pretty girl. I saw some pictures I was looking at yesterday of her where you can tell she was doing one video I did see. She was doing an interview with the radio station, and she had, you know, her hair was shaved off on the side, and she had her hair down over her eye. You could tell she was hiding a black eye or something. And then when you really, really look in her face, she looked like she was empty. I'm telling you, if you ever looked at stuff, go back and look at it again. Now knowing what we know, it's crazy. This radio interview, I don't remember ever seeing it, but she looked like so empty in this video. It was really disheartening. When you said in your direct testimony that he was a larger than life figure or personality, what did you mean by that? Larger than life? I mean, he's a charismatic, like big personality that everyone really loved. So larger than life would be that. Thank you. And you testified that you were in love with him and wanted to make him happy, right? Yep. What about him made you fall in love with him? I haven't thought about it in a while. Oh, go Cassie. I like that answer. The beginning of the relationship was really, I kind of spoke about it already. It was really fast and fast paced, scary. But the more time I spent with him and got to know him, it was just his really personality, and at least what I thought was his really personality came out. And I liked who he was. Yep, there behind the eyes. Unalive behind the eyes. Yep. What about it did you like? Just very sweet. Attentive. Yeah. You have repeatedly testified on direct that you loved him and therefore wanted to make him happy, right? Yeah. And you didn't want him to think that you thought withdrawn. You testified that you were afraid that he would find someone else if you did not agree to have X with him in the way that he wanted, right? Objection, Your Honor. That mistakes her testimony. You testified that you were afraid, withdrawn. You testified, you stated when you really care about somebody and you're in love with them, you don't want to disappoint them, right? Yes. And that was, and that reflected how you felt at the time with Mr. Combs, right? Yes. And you testified, I want to be, right? Yes. And you testified, I didn't want him to think that I thought anything bad of him for it, right? Right. What did you mean by that? Objection, Your Honor. Can we find what it is in that message and a time period? It's referring to freak offs. I can repeat it. You were asked, why did you agree to try a freak off? You answered, I wanted to make him happy. I was in a really significantly mature relationship that I don't think I was prepared for. Now that I look at it, but yeah, I loved him. I didn't want him to think that I thought anything bad of him for it. I just wanted to make him happy, right? Yep. That's how you felt at the time, right? At the time, I wanted to make him happy. Yep. And you also testified about a communication that you had with him where you said, I love you so much. You make me a better woman, daughter, sister, person. I hope you always know how much I love you and appreciate you, right? Objection, Your Honor. Can we get a time period for that quote? He said no, overruled. Sorry. Isn't it true that you testified that you had previously told him, I love you so much, you make me a better woman, daughter, sister, person. I hope you always know how much I love and appreciate you, right? I definitely wrote these messages, yeah. And that's how you felt at the time. Yeah, whatever time that was. Yep. We will get there, I'm sure. Okay. And you also wrote, you can't wait until we have a baby of our own to celebrate Father's Day. I love you with all of my heart, right? Oh, that message still bothers me. Yes. And you were asked why you sent that message, and you said, because I loved him and it was Father's Day. Yes. And you knew he would appreciate that as a father. I thought so. You knew that he had 6 children at the time, right? Yep. You also testified that you wanted to be around him, and you wanted to be around him for the same reasons as everyone else at the time, right? That's what you said yesterday. Okay. And you said it's just this exciting, he's just this exciting, entertaining, fun guy, right? Yep. I'm sure I said that. And that's how you felt? Mm-hmm. You said it felt special because not a lot of people got that kind of time with him, right? Yep. And that you really fell in love with him and you were just like a little shadow for a little while. Yes. You also testified that it was a very different relationship from any other relationship you had before, right? Well, it was, yes. Why are you just going over the testimony that she gave? This to me is crazy. Redundant as it seems, their exhibits that they gave to the government that they were going to use is just maybe she's getting to something. Let's see. Well, it was, yes. It was excited. It was much different. And it was passionate. There was passion, yes. She don't even understand. Cassie right now is doing a great job with answering her the way she's answering these questions. Like, oh, yeah, you're saying all that, but the fact that the defense is not putting a time, a period of when they're talking about, like they're just trying to make this a broad situation up until the time, do the whole relationship up until the time that she left. You could put this narrative out here, but it does not make sense. At some point, it doesn't make sense. Because if that's the case, and if that's how she felt all the way through the relationship up until the time she left, she would still be with him. She wanted to be acknowledged and he refused until he mentioned her at the award show after so many years. And at the award show, they weren't together. Remember? That was the day Young Miami was in the audience with the sign looking stupid, holding up, talking about go Poppy. Kim passed, and she knew that he needed a friend at that time. So yeah, she reached out to be that friend. She knows she had spent time around, her children. She, were close to the children. So yeah, they just lost their mother. But now that's being used against her in this case. But it's all, anybody with a brain, like I said, can see right through that. Anyhow, she said there was passion, yes, and it opened up your world tremendously, right? There was not really a yes or no answer to that one for me. Did it open up your world in a different way? Yeah, I'll say that. Is it fair to say that he trusted you with his secrets? I think that's fair to say. And that meant that you held a special place in his heart. Yeah. And that you wanted to keep that trust. Yep. And earn that trust. I don't know that I wanted to earn it. You did earn it. I did earn it. Yeah. So to make him happy, you told him that you wanted to do freak offs, right? No. There is a lot more to that. I'm sure we will get there. Can we please put up Defense Exhibit 1159 just for the parties, the court, and the witness? Ms. Ventura, after you have taken a look, can you tell me if that reflects the conversation between you and Mr. Combs on August 5th, 2009? Okay. Move for admission. Excuse me? Does this reflect the conversation between you and Mr. Combs via BlackBerry on August 5th of 2009? It looks like a real conversation, yes. Move for admission, no objection. 11:59 will be admitted. Can we begin reading and I will be Mr. Combs, the fourth message from the bottom and go backwards? Would that be at the me too? I'll begin. I miss you already. Me too. When do you want to freak off? Laugh out loud. And that's Sean asking. Laugh out loud. I'm just going up to change and put my ring in. I just picked it up. I'm always ready to freak off. Laugh out loud. LOL, LOL. LOL. Let's just pause there. When you say I'm always ready to freak off, this was just sent on August 5th, 2009, correct? Yes. And how long had you been dating Combs at this point? Almost 2 years. And you have already had freak offs before this, correct? Yes. I'll continue reading. You tell me the day. You choose. It can be whenever. Name the night. I feel like the weekend, like a Friday night would be best because we'd want time to recover for work or the work week, right? This upcoming weekend, the 8th, is the only one I have until the 28th. Okay, I'm on it. Laugh out loud. Okay. But if you can't, we can always do it during the week. You know that doesn't matter to me. Can we pause? When you say we know that doesn't matter to me, you're saying that you understand that Mr. Combs knows that you don't mind whether or not it's on a weekend or during the week, right? That's what it says, yeah. Okay. Then Mr. Combs says Friday it is. I wish we could get Jules here. Laugh all out. Maybe we could. We don't know him that well, though. You want to call him and fill him out? Yeah, I can do that. Call him now, please. You want me to make you a bowl? What do you understand make you a bowl to mean? Some food. Was this entire text message exchange kind of typical of communications with Mr. Combs? Somewhat typical. One of the conversations. Can we please put up for the parties, the court, and the witness defense exhibit 1162? Does this reflect the communication between you and Mr. Combs on August 7, 2009? It looks as such. All right. And they move for admission. And Ms. Johnson, we object to hearsay, and the judge says it's overruled. So I said that we were going to be stopping at a very awkward point. And I do have to stop now and go and take care of my mother. So I will go live later on when I get a more exact time. I'll go ahead and I'll share the thumbnail so we can pick this back up. And then that's going to be that on that. All right. And I thank you guys for coming and rocking out with me on such short notice today. I'll be back later. I'm going to end the show the way I always end it, making sure that I bring awareness that men get breast cancer too. Because of the stigma surrounding the word breast, we have changed the word to peck and or chest cancer here on the Survivor Speaks channel. So let's continue to end the stigma and continue bringing awareness that men get breast cancer. And to all of my ladies, please make sure you are getting your mammograms, filling on your boobies to make sure that you are all right. All right. And don't you dare let anyone come into your house and disturb the peace that passes all understanding. I'm Survivor Speaks, and I'll see you guys later on today in the next live. Peace. Survivor Speaks is the name at the end of the day. People love me or hate me, I don't care either way. Breast cancer busted through like a leaf in the night. A cancer's ass was knocked out before the end of the fight. A champion coming through, knocking everything out. This is hard if you see, I do nothing for clout. Just like cancer, I'll let nothing take me out. So be respectful when you step foot inside of my house. Hold it clear to have your ass escorted on out. So hop up out the bushes, wrap your feet, take a seat, and get comfortable and chill with your girl. Survivor Speaks, yeah. Hey, hey, hey. Who, what? I'm Survivor
time is it? What time is it? What time is it? It's time for you to hit that like and subscribe button and turn on that notification bell so you get a notification each and every time that I go live. Yeah.